Good morning and good afternoon and good evening. I'm Liz Stern, and it's my pleasure to welcome you to our 1000 series on Brexit. 1000 is a Mayer Brown series that addresses the top 10 issues that employers are navigating in this transformational era of a global pandemic and all the evolution that has followed the global pandemic. And certainly Brexit is one of those critical issues. Among the other issues that 1000 covers are the pandemic itself and what impact that has on public health and on the economy, the U.S. election, IBOR, and again, of course, Brexit. But there are quite a few issues, and we invite you to participate in them with us. Today's session, however, is on the long-awaited shift that is due to happen, or so we think, 1st of January 2021, and what will happen if UK employers need to address their EU work core. And as we're thinking about EU nationals in the UK, we're thinking about all nationals of the EU single market, i.e. the EU, the EEA, and Switzerland. And we'd like to go through and hit what the top 10 issues are within that context for employers to navigate. We will next week at this exact time host part 2 of this webinar. And in part 2, we'll be addressing how employers can navigate UK nationals going into that EU single market after the 1st of January, the flip side of the coin, and how we expect that to work. And we look forward very much to your comments and questions, which we invite you to put through in the Q&A on the chat room. But with this, I'd like to start the session by inviting my colleague, Chris Chapman, to give us an overview on what is happening with Brexit 1st of January. How is it, Chris, that we might even possibly now be wondering when the page will turn and how the page will turn?
Thanks, Liz. So my job is to give an update on Brexit negotiations as an introduction. We hoped we might be able to report a breakthrough. I've been refreshing my phone, but there's been no breakthrough. This has been a theme of Brexit. And I just wanted to start to remind ourselves where we've been. It's hard to believe it's been 4.5 years since we voted to leave the EU. A lot has happened in that time. We've had 2 elections, we've had 3 prime ministers, but we still haven't really left the EU, and still nobody really understands what it's going to look like when we do. But we are at another deadline, and we think, we're told, we believe this might be the last deadline. So if the UK and the EU have not agreed something by the 31st of December, we think the UK will finally leave Europe in a no-deal scenario. Now, in reality, that deadline might have to be a bit sooner. Any agreement agreed by the negotiators will need to be ratified. We've been reminded by the media in Europe recently that that's not something to be taken for granted. We've got EU leaders warning that they're concerned that their negotiators might be exceeding their mandate. We've had some votes in the UK Parliament recently on COVID where government politicians have rebelled. We may get the same on Brexit. But we're at a cusp, and I want to move to the next slide just to summarise where we're currently up to. We're at a deadline, as I said. There've been a few before. There's been some other deadlines in Brexit. That's what the slide illustrates. But as I said, we think we're not going to miss this deadline. Now, where are the negotiations up to? Well, it's actually remarkable how little we know about what's been agreed and what hasn't been agreed, given the size of this thing and its importance. But what we're told is it's come down to some very narrow issues, and people do think a deal is going to be done, although both sides are making it very clear that they're prepared to walk away if they need to. What are the narrow issues? Well, we're told fishing rights for the UK, surely that's not going to be a deal breaker because they could, it's not very important to the UK economy, but who knows, they may walk away. The EU concerned about level playing field. They're concerned about the UK possibly using state aid or something else to give itself an unfair advantage in the future. They're also, maybe not surprisingly, worried about the UK breaking its word in any agreement, given recent statements the UK government has made that it intends to do just that with other agreements. So this is where we're at. What's going to happen in the future? It's my last bit of it, and we think there's four categories we could describe as happening next. One is that there's no deal, no agreement reached. People think that's pretty unlikely now because we're close to an agreement, but for the reasons I've discussed, it is possible. We could run out of time, we could fail to ratify, something else could go wrong. So it's possible, but people think unlikely. We could get a deal. That's the second option. Any deal at this stage we know is going to be very high level and light. It's actually going to be pretty close to what a no deal would look like, but we could get one. People think that's quite likely at the moment. Another option is we have a further extension, another missed deadline. If you were a neutral observer, you might think that was the most sensible thing, but pretty unlikely, people think, given the statements that have been made up until this point and where heads are at the moment. And the fourth and final option is sort of a hybrid of a deal and an extension. So this might be a deal where there's a delay for parts of it to be implemented, or a deal where there's other mechanisms to provide for issues to be revisited or redealt with later. That's quite a likely possibility. Anyway, that is the Brexit update in my short introduction. I hand back to you, Liz.
Thank you, Chris. It's very interesting. The latter option fascinates me because it reminds me of budget appropriations in the United States when we end up doing something to get the government to come back to life after it shuts down and there's a cliffhanger and we somehow muddle our way through. It seems very difficult with regard to how many regulations are affected for that to be the cliffhanger for Brexit. Having said that, let me ask my good friend Ben Sheldrick from Magrath Sheldrick, who will be speaking to immigration issues today. Ben, does it really make that much difference for mobility? In a way, mobility, the movement of people, is already teed up. That is one area that we know the direction of what will happen. But what do you see as the difference if these options occur?
Well, thank you, Liz. Yeah, no, that's a really, really important point. I don't think it's going to make a huge amount of difference to mobility on the 1st of January, deal or no deal. It certainly will make an enormous difference in terms of trade and the potential for lorries queuing up at Dover and Calais and all sorts of complications arising, which would be very difficult, particularly in the context of a pandemic that we're trying to manage at the same time. But you'll remember from previous sessions that citizens' rights were front and center of the first stage of negotiations and are a very important chapter in the withdrawal agreement. So the protection of EU citizens' rights is rock solid and is agreed and ratified, and we'll talk a little bit about that, I think, as we go along. In terms of immigration policy, the UK government took a decision very early on to step outside the free movement zone, the free movement of people. And of course, the single market, the EU will not negotiate separately the pillars of the single market, of which free movement is one. So in terms of immigration policy, we will see a big change on the 31st of December, 1st of January, and that again seems to be pretty set in stone. I would be very surprised if an agreement came forward in the next few days or week or so, which included any kind of special mobility provisions. I think that is already decided. So, yeah, having a no deal would be very problematic. But I think in terms of what we're going to talk about for migration policy, we know the direction of travel.
Great. All right. So let's move on to our top 10 issues in view of that. From the 1st of January 2021, what's really going to happen is the UK now will create an equivalent policy for EU nationals as for other foreign workers. And that involves a shift significantly to a points-based system. And that points-based system will essentially eliminate what the prior quotas were, which were, of course, more manageable when you were dealing with the EU workforce not counting toward the quota. But that PBS system and how it works is really critical to our discussion. What does the enter free movement mean for my legacy EU workers. We are covering the top 10 issues. The first issue is, before we turn to that PBS policy, how do you as employers protect your legacy workers who are EU nationals that are in the UK? Next slide, please. Go ahead, Ben.
Okay, so this is why the 31st of December is so important in terms of legacy EU workers, because it's the end of the transition phase. So in legal terms, we left the EU on the 31st of January 2020, but that was very much a point of no return from a legal perspective. We're now still in an implementation or transition phase, which reaches its end point on the 31st of December, and there will be no extension to that. I'd be very surprised if at the very last minute the UK government and the EU agreed some kind of extension. That should have been agreed in June, and in any event, it's just not politically, I think, credible for this government to ask for an extension at this stage. What does that mean in practice? It means that EU citizens who are already in the UK are protected if they're exercising a treaty right, and indeed any EU citizen coming into the UK under free movement provisions between now and 11 p.m. on the 31st of December is protected and can be protected by the withdrawal agreement. The 11 p.m. is relevant because of the time difference with Europe and the UK. And we've talked about this in previous sessions, so I'm sure many of our attendees will be aware of it. But we have a settlement scheme that is the product of the withdrawal agreement, and it means that EU nationals who are here or who come in before that date can apply under the EU settlement scheme, either for settled status for those who are here for 5 years, or pre-settled status if they haven't been here for 5 years. And pre-settled simply means that they can stay until they have accrued the 5-year mark and can apply for settled status at that point. So this is, really important because the 1st of January is when our future immigration controls and the points-based system that we're going to talk about comes into being, and it essentially means that we're outside the single market for the freedom of movement of people at that point. And the new immigration rules, which run to over 500 pages of complicated text, come into force on the 1st of January. So worth remembering that there is a grace period. You can see reference there to the 30th of June 2021. So it's still possible to apply under the EU settlement scheme if you qualify for the next 6 months after the end of the year. So it's still open. It's a process that can be done digitally. So it remains open, but you only qualify if you arrived on or before that date and time, 11 p.m. On New Year's Eve. So this is, as I say, the protections contained within the withdrawal agreement that's been ratified with the European Union and protects citizens' rights. And of course, it's worth remembering that the same applies on the other direction. So British citizens who are in Europe qualify as well under the withdrawal agreement in exactly the same way. They'll need to apply under the local administration schemes in the country in which they are residing, but there is reciprocity within the withdrawal agreement in terms of citizens' rights.
So this is the easy one that's really pretty well known. The dates to remember, dates and times, 11 p.m. on 31 December, and really June 30th of June 2021 in the European way, for anyone that has not yet applied. Next slide, please. We mention only here, just for your reference, and we will send the slides afterwards, that there are also benefits under the settlement scheme for the non-EEA family members who may choose to trail with the spouse. We provided previously guidance, and it's available on our Brexit site, as to how they may do this, but please do not hesitate to ask us. The important thing is that they also must apply on time, these trailing family members, spouses and partners, children, and in certain cases, other relatives such as great-grandchildren, et cetera. We also will just mention that Irish citizens will continue to be protected as part of the Common Travel Area Agreement, even though they are, of course, part of the EU. And you will have individuals in your poor that already have indefinite leave to remain, and they are protected currently but need to convert to settled status. So there is a checklist of actions that must take place in order to protect that legacy workforce. The Home Office has a site on the EU settlement scheme that is quite helpful, but employers need to know who these people are, where they go, and give them guidance to ensure that they don't miss the deadline. All right, let's go to issue 2 in the benefit of time. Now, here it is, PBS. Ben, what does the end to free movement mean for new applicants from the EU who are applying for employment in the United Kingdom? Go ahead, Ben.
Sure. Well, in very, very simple terms, it means that there's a level playing field that treats EU citizens in exactly the same way as non-EU citizens are treated. So until now, we've had 2 streams of immigration into the UK. One stream from Europe benefiting from free movement, and others coming from the rest of the world who have to qualify under our immigration rules and criteria. And just very briefly, this is the way the points-based system looks. So at its core is sponsorship of skilled workers. And that is why it's so important that employers have a sponsor license. They may not have needed one in the past if they've relied very heavily on EU workers, but moving forward, more and more employers will need to engage with and understand the sponsor regime, which is very similar to the one that has existed up until now under Tier 2 of the points-based system. You'll see in blue there the 3 core areas that require points, and they are mandatory. So you need an offer of a job by a sponsor, has to be at the correct skill level, which is RQF3, slightly below the skill level under Tier 2, and also the person must prove that they have sufficient understanding and ability to communicate in the English language. That may be difficult for some EU citizens who haven't got formal qualifications in English. Obviously, there are many, many languages spoken across Europe, and the Republic of Ireland is the only one that has English as its primary language, and obviously they don't need to worry about this in any event. And then there are salary thresholds, the minimum being if you don't qualify under another area, 25,600. So you'll see you get 20 points for that. You need 70 in total, so you get 20, 20, and 10 under the blue, the core area, and then you can pick up the other 20 if your salary is at that level. If not, there are ways in which you can accrue points. For example, for specialists with PhDs in technical subjects, they can get 20 points for that, and therefore their salaries could be at a lower level. Potentially people entering into those professions from a starting point may not be paid at a high rate, etc. So without dwelling on it too much, you'll see that there are a number of ways in which you can trade points, particularly, for example, under shortage occupation, may be paid less than 25,600. You can accrue points, which would enable you to be paid below that level. But the 3 core areas are there highlighted in blue. Very similar to the current arrangement where sponsors have to take responsibility for the individuals that they employ and assign certificates of sponsorship for genuine positions in the business.
So Ben, really as a practical matter, the salary threshold of 25,600 is a real threshold. I mean, as a practical matter, that is generally going to be the threshold for sponsoring skilled workers.
Yeah, it's worth remembering that that is the minimum. So you have to pay the higher of 25,600 or the going rate. So there are obviously many, many jobs in the labour market that pay more than 25,600. And you have to pay the correct rate for the job. So you can't bring in cheap workers from overseas and simply pay them 25,600. You have to go to the relevant code of practice to see what the acceptable minimum salary is for that particular role. So even though the threshold for admission is 25,600, that in many cases will not be the going rate for the particular job. So the likelihood is that the sponsor will be required to pay at a higher rate.
And in that regard, let's turn to the next slide where we've outlined that there still needs to be a requirement to match the job against that occupational code of practice, which Ben just referenced, and that FOC code will carry with it what those minimum threshold levels are. This is one thing that we do have in America and quite a lot of controversy around currently, Ben. Very, very familiar with it. Ben, it's really worth I'm sorry?
I was just going to say that's why the immigration rules are 500 pages long, because there's so many potential roles within the UK that can be sponsored, and they're all set out in the immigration rules with the relevant salary threshold that applies to them. Sorry, Liz, go on.
No, absolutely. I was just going to say, I think it's quite interesting, though, if you wouldn't mind highlighting the last two bullets, which are additional points that have shifted now in this system that is much more skills and salary oriented. Would you mind addressing those two bullets, please?
Oh, well, this is a really important point. Yes, thank you, Liz, for pointing it out. So under the Tier 2 scheme, there was a requirement to advertise externally within the resident labour market, which obviously currently includes the European Union, to show a genuine attempt to recruit within the labour market before you can sponsor. That's been taken away under the new scheme, which is a really important point because it will save a lot of time and compliance and cost for employers. So that's a big change. Basically, the purpose of the scheme is still to protect the resident labour market, which, of course, now is much smaller because it includes the United Kingdom and the Republic of Ireland only. But there are various mechanisms within the programme that will disincentivise employers from engaging with it, particularly around cost. It's a very expensive scheme, the UK immigration of taxes and levies that are associated with it. So employers will really only want to recruit from outside the resident labour market if they think it's worth that investment. For example, there's an immigration skills charge per sponsored migrant of £1,000 per year of sponsorship. There's an NHS surcharge which goes towards our health system as well. So there are protections within the scheme that disincentivise engagement with it, but the resident labour market test, which has been in existence here for many, many years, is falling away. And strangely, if you take that in conjunction with the lower skill threshold and the potentially relatively benign salary threshold, you do in fact have a relatively liberal immigration scheme here, an open immigration scheme, perhaps one of the most liberal in the Western democracies, which may seem a little odd given the context of taking back control and wanting to put a halt on too much migration into the UK, which was the narrative behind the referendum, certainly in terms of migration issues. Skilled workers can seek permission for 5 years from the outset and obtain permanent residence, what we call ILR, or indefinite leave to remain, after 5 years continuous employment. That's quite standard under the immigration rules.
I think in contrast to the resident labor market test records, this also will make it much easier for employers to keep their records of what they've done, keeping proof that the payroll has been made, that the job duties have been supplied, is much easier than being prepared for an audit that happens several years down the road to demonstrate that all of the appropriate screenings have been done. We've seen that in the course of our audit work, but there still will be an audit trail that needs to be maintained. Let's move to the next question, please. Issue 3, will I still be able to transfer EU workers from affiliated EU offices to the UK? Oh, the much used Tier 2 ICT question, Ben.
Yes, so you Liz will be, and the audience will be very familiar with the concept of an intra-company transfer, which is somebody who's employed by a multinational organization and is being transferred into the UK because they've got proprietary knowledge of the company and its methodologies and business, etc. And this scheme is being preserved under the new arrangements. And for those of you who work with intra-company transfers, you'll see that the criteria are the same as have been in existence for some time. 12 months prior employment. The skill level is slightly higher than the skilled work scheme, but set at RQF 6. The salary threshold is much higher, 41,500, but there's no English language requirement. The cooling off rule, which requires people to leave at the end of an assignment and not return for a period of 1 year, has been amended to make it slightly more flexible. So the new rule is that an intra-company transferee shouldn't be in the UK for more than 5 years in any 6-year period, which is slightly easier to navigate. The previous cooling off rule was quite clunky. But the question that I would ask is whether employers will really want to engage with this route in the future, because the skilled worker route doesn't require external advertising and also leads to permanent residence. So it may be more attractive in the future to rely on the new skilled worker route than to box oneself into the criteria that apply under intra-company transfer. And you'll see that last bullet point is that the government, the Home Secretary, has asked the Migration Advisory Committee, which is a body of economists that advise on migration issues, has asked them to look at this route and to decide whether it needs changing, abolishing or amending or kept in place as it is, and they'll be reporting back next September. So watch this space. We'll see how this develops over the course of the next few months.
Ben, is the salary threshold for ICT, the 41,500, also subject to a review against the skilled occupational classification, such that that's only the minimum threshold, or is
you'd still have to pay the going rate if the going rate is higher.
Got it.
But you can't pay less than 41,500.
Then indeed, I agree with you. I see absolutely no advantage to the ICT in the current system. There is no quota on skilled worker.
I was just going to say the only potential advantage would be for people who can't prove their English language, because that may take time in terms of going off to a test center to take an English test, etc. So I think you're absolutely right. The only reason I could think of why you would want to use it would be for somebody, and remember, Europeans generally do speak very good English, but they may not necessarily have any proof of it, and so it might be advantageous to use this route.
Ooh, that'll be very interesting to watch that. But I can see that a business on English as a second language will start to grow within the within the UK. Next slide, please. Issue number 4. When can EU nationals travel as business visitors into the UK? So when we're talking about just business travel, what are we dealing with? So really the question of business visitor versus whether someone is a skilled worker, or I should say someone who requires a work permit, it's a long-standing question of immigration law all around the world, and the UK is no stranger to it. The basic rule is when the individual is coming into the UK and not engaging in productive work, i.e. not providing services to a recipient company, but instead engaging in business activities, conferences, contract negotiations, shadowing, perhaps a short knowledge transfer that is really limited because really it's necessary in order for them to fulfill their work for their employer in their home country in the EU. But it is really limited to non-productive activity. Pay and supervision, exclusive personnel authority is outside of the UK. Limited to 6 months on any visit, but you'd really be straining if it's a 6-month business visit. To be honest, you're asking for close scrutiny. How can it be non-productive activity when someone's spending that much time in the UK? And typically, you would anticipate that dependents aren't joining. There are times when dependents join because it's holiday time and it might be worth a visit, and there has been so much free movement. But when you're looking at foreign workers who have not had the benefit of the EU, we often look at making sure that family members aren't coming, kids aren't enrolling in school, et cetera. Business visitors, not productive. Skilled workers, or ICT, or they're work authorized, they're really they're performing services for a company that is receiving their services. They are productive within the UK. And they are subject to the salary and skill and occupational requirements that we just talked about. They would have UK payroll and supervision typically. Even if they don't, however, that service provision can be enough to risk that being considered a worker versus a business visitor. So now EU nationals need to get accustomed, and employers need to get accustomed to really threading that needle. Is it business or is it something that requires a work permit? And what we will anticipate is that there will come a time when both the border officials and the auditors from the Home Office will become sensitized to this issue in particular, because they will see it as a natural way for employers and EU nationals to evade the new required level playing field. So be on the lookout for how you are evaluating your business visitors. Next slide, please. Can I recruit, issue number 5, can I recruit EU graduates of UK universities? Yes. The UK actually is has received very positive press internationally for welcoming students into their fold and trying to attract the best and the brightest. The graduate visa program will open in the summer of 2021. International students, whether they're EU or not, who were sponsored by a Home Office licensed student sponsor will be eligible, and the visa will give them a maximum of 2 years, unless they're PhDs, which is 3 years after completion of studies to engage in work. And then I assume that then they could transfer into a skilled worker visa category. Exactly. So very similar to what we see around the world. They enter the state. They have completed their graduate program. They obtain their graduate visa as students who have graduated from an appropriately sponsored institution. They work for an employer and get their clinical practical training, and then they are allowed to convert to a skilled worker visa and become part of the workforce. So if we summarize all that we've heard so far, there is in addition to the protection for current workers through settled status, there is a skilled worker route that will apply across the board to most hires by UK employers in the new era, the new post-Brexit era that starts in 2021. There is still an ICT, intra-company transfer visa, which I think Ben's pointed out astutely has that benefit of perhaps the less stringent English language aspect that the skilled worker visa has. And there are graduate student visa options. We also mentioned in the slide youth mobility programs that may give employers opportunities to attract youth to their ranks. But really, if you think about it, those are the 3 main bases for sponsoring individuals that are rank and file part of the workforce and probably the vast majority of foreign workers. And they all 3 apply not only to the EU, but to any foreign workers. Americans, for example, we will need to make sure that our folks apply under those same categories and qualify. Next slide, please. The next slide is really issue 6. Are there special options for exceptional science and research talent, particularly if your company has a significant R&D? There is a fast-track team for absolutely top-of-the-line research and scientists. I think today, simply for the benefit of time, we'll put this category to the side and discuss it on a future occasion. But we do want to make you aware that there are opportunities for these extraordinary solutions for individuals that might be quite relevant. And certainly, one can imagine that researchers working on pandemic issues would be particularly favored in the current environment. Next slide, please. Issue 7. What happens if we need EU workers to remain in the UK indefinitely? And I'm actually, Ben, going to surprise you by asking you to speak to this question, just so the audience has the benefit of a different and informed voice. Let's ask Ben to take this one on.
No problem. So the immigration rules in the UK generally do provide for the acquisition of permanent residence. As I mentioned before, we call it indefinite leave to remain. Sometimes you'll see it referred to as settled status, and in particular, under the EU settlement scheme, it's referred to as settled status. But the general principle is that if you're in the UK in a qualifying category for a period of 5 years, you can apply for settled status, indefinite leave to remain. So we've already talked about EUSS applicants under the EU settlement scheme. We know that it applies there. Skilled workers also under the new points-based system will be eligible after 5 years, but not for the ICTs. But one of the good innovations under the new regime is that it is possible to switch status in country from intra-company transfer to the skilled worker route. And certainly in the audience, if you have migrants currently working for you under intra-company transfer and you think it might be advantageous to keep them here in the UK over the long term, and they may want to settle here and make it their home despite the original intention just to come on assignment, it's worth noting that it is going to be possible to switch into the skilled worker route for these legacy intra-company transferees from the 1st of January. So that's worth bearing in mind. Visitors know the very nature of visits, as Liz has pointed out, is that they are temporary and do not lead to settlement in the country. Global talent, yes, after 5 years, but not the shorter term programs like the graduate visa holders or the youth mobility scheme. But as Liz mentioned, it may be possible to switch into skilled worker in any event and then start the 5-year period from the date of the switch of category.
I think this is just really important to keep in mind as a shorthand who it is that you have that will be able to get that long-term benefit, because I do think, Ben, the ICT ceiling that we faced before for Tier 2 was a continual problem for clients of ours who had just happened that having planned for 5 years, it turned out that then whatever needs the company faced, the employee was just absolutely wonderful and a great fit. There they were stuck with having to remove them. This is a much more rational, realistic.
Sometimes the family as a group decide that actually they would really like to take the opportunity to stay in the UK. Don't know why you'd want to do that now we've left the EU, but leaving that aside. So yeah, I think, circumstances change, intentions change. So this is quite advantageous, I think.
That's wonderful. So I suppose that if I want to fulfill my dream of moving as a Mayor Brown partner to the London office once the pandemic passes, I might be able to qualify as a skilled worker and then convert to indefinite leave to remain. So Miriam, I'm keeping that in my back pocket.
I'm happy to confirm that you're skilled, Liz.
Thank you, Ben. Thank you. That's wonderful. Issue 8. What compliance mandate must I, the UK employer, fulfill by 1 January 2021? Thinking about, again, audit and enforcement, what do I need to fulfill? Go ahead, Ben.
Okay, so essentially the good news really is that the new skilled worker scheme very much or looks very similar to the previous Tier 2 scheme, and in fact the licenses that employers currently have will automatically move into the skilled worker scheme. So that's a real benefit. It means that those audience members who work with the Tier 2 license do not have to worry about applying for a new different license. It's morphing into the new scheme automatically. And so if you have a Tier 2 license, you'll be familiar with the essential requirements which are set out there, and essentially mean that the beneficiaries of the UK immigration scheme also have to take responsibility for ensuring compliance and potentially enforcement as well. So monitoring immigration status, ensuring that legal right to work checks are in place to prevent illegal working, keeping records of the duties and responsibilities that an individual sponsored migrant does, and ensuring that they are consistent with what's set out in the certificate of sponsorship, keeping records of the recruitment process as well, although in the absence of the resident labour market test, that particular requirement should become less onerous in the future. And then tracking and monitoring migrants and reporting, for example, if a migrant ceases to work for you, if they decide to leave for whatever reason, or if they're dismissed for whatever reason, that needs to be reported. keeping proper records of addresses, etc., where the person is working, and also just ensuring that they are paid at the correct rate and that they're doing the job that they're sponsored to do. So all of these obligations remain in place, and sponsors, I guess the biggest takeaway is that sponsors potentially have a much larger population of people for whom these obligations apply because of the shrinking nature of the labour market here, and the fact that the demographic of potential sponsored migrants is much bigger because of the European Union joining that particular route and the level playing field. So record keeping is going to be fundamental, and a legal right to work checks are really, really important.
Yes, I think this one we've been over before, Ben, and I think it's fine for us simply to put it on the screen. But we will talk at the end. We'll wrap up by our last issue will be what best practices can you follow as an employer in view of the fact that you do have such a larger responsibility, and with higher volume comes the opportunity for systemic gaps, which is always an enforcer's dream. So we'll talk about that. But before we do that, let's turn to issue 9 and ask my colleague Miriam Bruce, who is one of the leaders in our UK employment practice, to speak to an issue that's absolutely critical and goes hand in hand with the changes to post-Brexit to immigration. Miriam, what employment law issues are arising for UK multinational organizations post-Brexit?
Thanks, Liz. So whilst employers have got a lot to think about from an immigration and mobility perspective, I think the good news is it's more straightforward when it comes to employment law issues, at least initially, because although most of our employment law derives from the EU, Brexit will actually have limited implications for employment law in the immediate term, because there's no immediate change to legislation planned. However, I think there are a couple of key issues from UK multinationals to watch out for in the immediate period after the 1st of January. So the first issue I think is relevant to what we've been talking about so far. As we've heard, the deal between the EU and the UK contains provisions on the rights of EU citizens living in the UK, and that includes protection against discrimination at work, for example. Now, existing anti-discrimination laws in the UK will be largely adequate to reflect these rights, which need to be observed even if we do end up in a no-deal scenario. And now where I think this is particularly relevant is in the context of recruitment. If employers move towards adopting a policy of not considering applicants from EEA nationals after the 1st of January, which may become a route some want to consider, I think that does leave the organisation vulnerable to potential claims of indirect discrimination on the grounds of nationality. So I think from an organisational perspective, you need to think through your recruitment process and to minimise the risk by considering the right to work option, which you just talked about, on a case-by-case basis, and really not until after you've completed the selection process. It's usual practice to make offers of employment subject to appropriate right to work checks, but it's key not to make right to work a filter. In terms of the second issue, I think this is definitely one that needs some close attention if you have a European Works Council in your group, because this is the one area that is going to change immediately on the 1st of January. So where you've got a European Works Council and you've got a UK workforce that participates in that European Works Council, I think there are two issues you need to start thinking about immediately if you haven't done so already. The first issue is, will you still let your UK workforce participate in a European Works Council post the 1st of January? The default position will be that they aren't able to participate, but of course you can allow them to do so on a voluntary basis, and there may be good employee relations reasons why you would want to do that. The second issue is that if you've got a European Works Council that's located in the UK, that will no longer be possible after the 1st of January. Employers will need to either designate a new location, the European Works Council, or they will need to allow the default rules to apply. And those default rules mean that the European Works Council would automatically move to the location in your group within the EEA, which has the most employees. And of course, that might not be a suitable solution for you. So I think it's worth considering now, if you've got a UK-based works council, whether you want to proactively assign a new home to it. And I think the final point I wanted to touch on is in relation to the future, because as I said, nothing's going to change immediately, but there is lots of speculation about what might be in scope to change. And there are some perennial favourites in that list, including working time, agency workers, and discrimination. So it's certainly going to be, I think we're going to be talking about this for a while to come as the government's focus shifts to the new world. And I would say I think we're going to be talking about Works Council issues in our next session next week. So do join us.
Miriam, just a question for you. Do you expect that EEA nationals, I guess, that have been accustomed to being welcomed into the UK as much as they wish, what do you anticipate in terms of claims that they might bring themselves? From our perspective on this side of the Atlantic, we'd expect that claims by individuals would go up if they're turned down for recruiting. And yet, realistically, that is going to happen. What do you see? Do you think that will happen right away? Do you think it will shift over time? What's your thinking on that?
I think the thinking is that discrimination is going to be the discrimination claims are really going to be the focus here, because in the UK, anti-discrimination law reaches far and wide and protects both nationality, anti-discrimination against nationality and race. So I think this will discrimination claims are always favoured by employees because they're potentially so valuable. They are uncapped claims in the UK, and you can bring them if you've never worked for an employer. So if you are rejected from a job, one of the automatic claims you might think about is discrimination. So I think that will be one to watch, and that's why I think it's important to get your processes, especially around recruitment, right, so that you can demonstrate the basis for taking on or rejecting people.
Sure. I can see that the communications and policies and training that employers will need to do will have to be revised to address this pool, because it just will be, my hunch is, a charged environment. Terrific. Let's go to the next slide, please. Issue 10 of the top 10. What is the most practical way to achieve required compliance, really compliance, and frankly, management of this portfolio of the workforce that will now include EU and EEA workers? You have to create what really is a compliance framework. And for it to have a resilient compliance framework in any area, it starts with having central leaders that have oversight over all aspects of the company's mobility compliance program. Those central leaders who are probably already working in the global mobility area will work with stakeholders that are in HR, are in legal, are in employee relations, and are perhaps involved on very significant business segments of the company's work. But those central leaders need to be empowered and they need to be held accountable for how they manage the program. They also need to be resourced and supported. One thing that those leaders will need to do very early on, if it isn't done already, is create a refreshed immigration policy, a document that really talks about what are the standards, what are the controls, how will the company make decisions as to when it is willing to sponsor someone for a PBS work permit, an ICT, a graduate visa, et cetera. And having heard from Miriam, really in a way that it's anti-discriminatory, but meets the compliance obligations of the company. When will the company elect that a skilled worker can, in fact, then move to indefinitely to remain? Is that something the company will support, or is it just left up to the workers? These immigration policies will need to address these issues because the pool of workers will be larger. And in addition, that refreshed immigration policy will need to address GDPR compliance, because all of this tracking that you're doing, there's a tension, an obvious tension with GDPR obligations, particularly with recruits who may not have given consent yet from a GDPR perspective. So a new immigration policy that really addresses this new era, the new normal, will be quite important. The third is an automated central tracking system that allows these leaders to be able to collect the data they need in a secure and GDPR compliant fashion so that they know who is where, when individuals are moving, whether there are changes to location or to salary thresholds or to job duties that need to be managed, and when renewals, changes, extensions, troubleshooting need to occur. That needs to be a very actively managed system by those leaders and whoever is assisting them on the ground with their monitoring of who's going where. That system also needs to ensure that right to work validation is occurring on time and being renewed for those that have expiration dates, because that policing by the Home Office authorities will unquestionably arise. Fourth, we suggest that the company set up a central place on its intranet where communications and training and guidelines are stored, both to mitigate panic as these changes occur. When the headlines start to occur that someone who is has been stopped at the border and turned back and perhaps mistakenly, that is a good place to help stem the anxiety, but also to show that the company is in command of what it plans, how it's managing the issues that are changing. And then finally, again, from a compliance perspective, having regular audits of each aspect of the company's obligation, right to work, business visitor compliance, visa expiry, et cetera, it's a part of the program. So leadership, standards and controls, ongoing tracking, reporting, and monitoring, communications and training, and auditing. That is a very fulsome compliance program appropriate to the changes that are happening now. And I might add that this program, when we discuss part 2 next week at this time, this program will also allow those central leaders to manage UK nationals in the EU, not simply foreign workers, all foreign workers, I might add, that are working in the UK. Next slide, please. One of the things that we have done at Mayer Brown, we've developed our own tracking system that we offer to clients called 10X Mobility. We developed it originally as simply a tracker of our own because we wanted it to have the flexibility to adapt to changing trends. That was pre-Brexit and pre-Trump administration in the U.S., but we're very glad that we developed it because it allowed us to put in certain aspects and bells and whistles that we felt our clients needed. That kind of tracking system that has the right security provides the audit trail in case your question, gives an ease to the user of being able to both have configured and customized reports, and is routinely updated for data both by your people and by your outside counsel or consultants, is very important. This is one example. You need to think about what example works for you. Next slide, please. A sample of what it looks like. With that, we are at 11:57. We have received a couple of questions, which, because we are late on the time, what we'll do is we'll send written comments back to the group along with a copy of the PowerPoint. And we would welcome any other follow-up questions that you wish to send to us. It's been a pleasure. Thank you to my very knowledgeable co-speakers and for them allowing the American here who just is so attracted to what's happening in the UK to participate with them. I again mentioned to you that next week at the same time, we will have part 2 of the Brexit session, and we would love to have you join us. Thank you very much.